COVID-19 injections weapons of mass destruction. Senator Lindsey Graham gives away the neocon playbook to the war in Ukraine, and actor Kevin Spacey breaking his silence on Jeffrey Epstein, Ghislaine Maxwell, and Bill Clinton. Those stories and more tonight. I'm Maria Z of zmedia.com, and this is Vigilant Fox's Media Blackout. Outlet in the world. The COVID injections have been hit by a new bombshell, with a top law professor labeling them as weapons of mass destruction. Dr. Francis Boyle, a Harvard-trained professor and the architect of the 1989 Biological Weapons Anti-Terrorism Act, which was unanimously approved by both House of the U.S. Congress and signed into law by President Bush, has issued an affidavit declaring COVID-19 mRNA injections as biological weapons and weapons of mass destruction. This was first reported by Dr. Joseph Sansone. Dr. Boyle's affidavit, which was submitted as part of an emergency petition for a writ of mandamus in Florida, argues that the distribution of COVID-19 injections violates several statutes, including the U.S. Code on Biological Weapons and Florida's statutes on weapons and firearms. This petition, aimed squarely at Governor Ron DeSantis and Attorney General Ashley Moody, calls for an immediate halt to the distribution of these injections in Florida and demands the confiscation of existing vaccine supplies. According to Dr. Sansone, the original emergency petition for a writ of mandamus was filed on March 3, 2024 in the Florida Supreme Court. It was later transferred to the Circuit Court in Leon County on March 20th. And after the Circuit Court dismissed the case on April 9th, it moved to the Appellate Court. The appellate brief was filed on Memorial Day, May 27th, 2024. Dr. Boyle, one of the world's leading legal experts on biological weapons, has added considerable weight to the case with his affidavit. The case already boasts a substantial body of evidence provided in the writ of mandamus, including affidavits from both med legal advisor and biotech analyst Karen Kingston and Dr. Anna Mahaicha. According to Dr. Sansone, the pleadings claim that the distribution of these injections violates several laws, including, and we'll just read you the highlights, biological weapons laws, federal crime of treason, domestic terrorism, murder and genocide, Florida Drugs and Cosmetic Act, fraud, accessory after the fact, and Florida medical consent law. Dr. Boyle's signed affidavit reads, pursuant to 28 U.S.C. 1746, I, Francis A. Boyle, declare under penalty of perjury, Act of 1989, that was approved unanimously by both houses of the U.S. Congress and signed into law by President George H.W. Bush with the approval of the United States Department of Justice. He references his book on biowarfare and terrorism there. He says, it is my expert opinion that COVID-19 nanoparticle injections or mRNA nanoparticle injections or COVID-19 injections meet the criteria of biological weapons and weapons of mass destruction according to Biological Weapons 18 U.S.C. 175, Weapons and Firearms, and the rest of the reference is there. The Gateway Pundit also previously reported that the Florida Supreme Court approved Governor Ron DeSantis' request to impanel a grand jury to investigate COVID injection manufacturers. This bombshell also follows an historic ruling just this past week by the Ninth Circuit Court of Appeals that the mRNA COVID-19 injection is not a vaccine under traditional medical definitions. Needless to say, the dam has broken and more people are starting to call these injections what they actually are: biological weapons and, per Dr. Francis Boyle, weapons of mass destruction. Dr. David Martin is the founding CEO of MCAM Inc. MCAM is the international leader in intellectual property-based financial risk management, and Dr. Martin has been on the forefront of speaking out from the beginning of this crime against humanity, has spoken at government hearings and inquiries, and has been tracking all the patterns of DARPA and NIAID funding for injection toxins. We're very honoured as he joins us now to discuss. Dr. David Martin, thank you for joining us today. We appreciate your time.
Maria, it is lovely to see you.
Well, this is an historic ruling right now. The Ninth Circuit Court of Appeals has ruled that the mRNA injection, the COVID injection, is not actually a vaccine under traditional medicine definitions. Can you talk us through this case and this ruling, please?
Well, yeah, let's go back to 1905, the very famous Jacobson case, which tragically has been misquoted by almost everybody for the last now 120 years. And we need to unpack what that case actually was. As much as the incumbency would like to tell you that it was a means by which the civil liberties of the individual can be overruled by the common interest allegedly of disrupting infection or transmission during a smallpox outbreak, which is what the Jacobson case actually was first argued around. The real question in Jacobson was whether you could actually have to still pay a fine if you refused taking the shot. It was not a mandatory vaccine ruling. It was the state interest has an interest in you getting the shot. If you don't, and they fine you $5 or $10, then you pay a fine. And that's what the case was. So for over 120 years, that case has now been misrepresented to be a pro-vaccine determination. What it in fact was a case that experimental gene therapy. That comes right out of their Securities and Exchange Commission filings. That is not Dave Martin's opinion. That's not somebody else's opinion. It is unambiguously what they said, which means that at the time that they were promoting what they were calling a vaccination, what in fact was happening was rather than promoting a vaccination, they were in fact promoting an experimental gene therapy. And they mislabeled it intentionally so that the public would be bamboozled into accepting it. So let's be really clear. That's a crime. That is actually domestic terrorism that was used to force people to take something that they would not otherwise take. That's the definition of domestic terrorism, and that's what it is. Now, I have said many times, Maria, as you know, that this was a bioweapon because in 2005, at the DARPA MITRE conference, where Ralph Baric made the statement that synthetic coronavirus fragments were, and I'm quoting right off of his CV, biowarfare enabling technology. Maria, I don't know if down under you guys have a problem with the common use of English language, but biowarfare enabling technology sounds to me like it's a bioweapon.
Yes.
And so it turns out that when you go and look at not only that, but then you go and look at this 7 CFR Part 331 definition of what selected agents and toxins are, which is the schedule of what a biological weapon is. It turns out that on that list, the spike protein associated with any modification of coronavirus is in fact a biological weapon. That's the definition of the ruling. And so this is where I want to point out something very specific. Since this ruling came out, as I said, fact checkers want to say, the Ninth Circuit Court ruling didn't actually rule that it wasn't a vaccine. What they actually said was the Jacobson case was misapplied because Jacobson relies on the disruption of infection or transmission, which is actually true. Those were the presumptions inside of Jacobson. But the Ninth Circuit ruling actually, ironically, triggered some responses which were very fascinating, where there were a number of people who said, well, even if the Ninth Circuit ruled the way it was, that liability protections were still in place because of the emergency use authorization. Famously, Aaron Siri of Del Bigtree's platform was quite prolific on X, saying exactly that point. But here's the problem. The problem is this is actually a biological weapon. And the emergency use authorization, the EUA, under a PrEP Act construction, which means the 2005 PrEP Act, under that construction, you are not authorized to use an experimental gene therapy or a scheduled biological toxin, regardless of being told your body to create a bioweapon. Your body then complies with creating an immunity to the thing you told your body to make. And this is where Aaron Siri's interpretation is entirely in error. Because the fact of the matter is, unlike the other things that he talks about in terms of injections, in this particular case, the injection is instructions to make the toxin, not instructions to stimulate an immune response. And this is the subtle difference that I think the Ninth Circuit got very correct in their majority opinion.
So I agree with you, and this is so vital, Dr. Martin, that we use the correct language.
That's
I just
correct.
want to bring up this just recently, law professor Dr. Francis Boyle, who drafted the 1989 Biological Weapons and Anti-Terrorism Act, says that the COVID-19 mRNA injections are weapons of mass destruction in a new affidavit. I know this is something that you've been saying for quite some time, Dr. Martin.
Yep.
I
Yep.
don't know. Do you think that people are starting to become more accustomed to calling this what it actually is, a bioweapon?
Well, I think that those of us who are actually pursuing the defense of humanity are, in fact, very much aligned with that. And there are a number of people who are actually starting to take this on board. You know that I have been very active in encouraging people not to use the term vaccine
Yes.
in this particular instance because it is a mislabeling of what the thing is. And we need to go back to the fact checkers on this. Fact checkers at Reuters, the AFP, everybody else is getting this wrong. The facts are that in their SEC filings and in the FDA records, there is no question that the official designation of mRNA is an experimental gene therapy. It is not a vaccine, and it has no vaccine properties whatsoever. Furthermore, everyone can download, and I have this so that people can have a look at it. Everyone can download the HHS and USDA select agents and toxins list. This is not hard to access. And what you'll see on this list, number 20 on the list, is SARS-CoV and SARS-CoV-2 chimeric viruses resulting from any deliberate manipulation of SARS-CoV-2 to incorporate nucleic acids coding for any SARS-CoV virulence factors. And this is why that line is so important. In 2016, in the proceedings of the National Academy of Sciences, Ralph Baric made the statement that the modification of the spike protein from the Wuhan Institute of Virology virus 1, let's get really clear. He didn't say any SARS coronavirus. He specifically said the Wuhan Institute of Virology virus 1, the spike protein derived from that was, and I quote from his paper, poised for human emergence. That was published in 2016, which means we know that the weapon was not only built, but the switch for the weapon was turned on in 20. This never was a virulent pathogen. This was the dissemination of a weapon that weaponizes the human body to make spike protein, which is a scheduled toxin, not an immune trigger.
So I want to ask you in relation to the Ninth Circuit Court of Appeals decision, what does that enable people to do now, Dr. Martin? Because I've heard commentary that it enables people, it may give people grounds for battery now. I mean, how far can people go with this?
Yeah, so let's be clear on the practice of law versus the letter of the law. The Ninth Circuit technically has now remanded the case back to the lower courts, saying that the Los Angeles Unified School District teachers can, in fact, bring lawsuits with respect to the vaccine mandate. That is what the technical letter of the law is. The opinion, which is actually part of precedent-setting opinion, and this is the key distinction I want to make, the opinion makes it unambiguous that the Ninth Circuit has determined that Jacobson is misapplied in this particular instance. And what that suggests is that for the first time, the illusion that public health interest was being served has finally been pierced by an appellate court. And that is a watershed moment, because now what we can do is we can now bring legitimate statements that say that the manufacturers willfully misled the public by mislabeling these things and calling them a vaccine. And by the way, that's a violation of the Federal Trade Commission Acts in the United States, and it's a violation of the Deceptive Medical Practices Acts that are largely in every civilized country. So the good news is we have that veil to pierce. But more importantly, and this is the very important piece, with the Ninth Circuit unambiguously saying the Jacobson waiver is not going to pass muster in their view, what this also does is, to your point, starts to give us the cracks that we need to pierce the liability shields against vaccine manufacturers and against the individuals, employers, pharmacists, doctors, nurses, hospitals that actually injected people. For the first time, we actually now have the ability to say that the Ninth Circuit has held that Jacobson was misapplied, that this did not stop infection, did not stop transmission, and as such, the public was willfully misled, which is a crime. And under the criminal statute, Maria, all the liability shields fall away, which
Fantastic.
means Pfizer and Moderna are both financially and criminally liable for deceiving the public.
That is fantastic news. I think we need to see more of that action happening from now,
Yep.
Dr. Martin. I think the public is ready. I think they depended on people just sort of forgetting about this, but it's certainly not going away. People want justice.
Well, yeah, and let's just point out very briefly that the myth that the World Health Organization has been circulating, that H5N2 avian flu is the new disease X that we're all supposed to fear. I want to be abundantly clear for everybody. H5N2 was available for sale from BEI Resources, which is NIAID's commercial arm that sells biologic agents. And there are a series of patents that make reference to people who have acquired H5N2 from NIAID. So before anybody falls for this nonsense headline that somehow or another avian influenza H5N2 is this new thing that just showed up, it's literally purchasable from a catalog at NIAID. So let's be abundantly clear. World, I am online at davidmartin.world, and Kim and I are always online trying to keep connected with people at fullylive.world. Maria, it's always good to see you.
Likewise. Thank you for your time.